Hi friend, welcome to the Company Law Adjudication and Appeal series. Today we are discussing Cuttack ROC adjudication order in the matter of the KKDIL Nidhi Limited for the violation of Section 92 and Section 137 of the Companies Act. Company name is the KKDIL Nidhi Limited, having registered office at Odisha, and in so-called notice, a reply and personal hearing on the basis of the supplementary inspection report under section 206 subsection 5 of the Companies Act, directed this office to take action under section 92 subsection 5 and subsection 3 of section 137 of the Act for the violation of subsection 4 of section 92, that is the failure non-compliance of the filing of the annual return within the due date, that is 60 days from the AGM, and section 137 subsection 1, that is failure to file financial statement AOC 4 within the 30 days of the AGM. Accordingly, this office initiated adjudication proceeding against the company and its director, officer in default. Hence, so-called notice under section 454 of the Act for the violation of section 92 subsection 4 and section 137 subsection 1 of the Act have been issued to the company and director, officer in default. In response to the said so-called notice, no response was received either from the company or from its director. As no response received either from the company or from the director, adjudicating officer issued notice of inquiry dated 3rd September 2021, fixing the date of hearing on 20th September 2021. But no, on the fixed date, no one is appeared before the adjudicating officer. Hence, the matter adjourned to 22nd November 2021. On the said date, this office received an email from one of the director requested for 30 days time. Considering her request, the matter was adjourned to 30th December 2021. On the fixed date, one of the director appear before the adjudicating officer and submit a written petition requesting for 1 month adjournment. Considering her request, the matter was again adjourned to 28 February 2022. Provision of the Companies Act. As per subsection 1 of section 92 of the Companies Act, every company shall prepare an annual return in prescribed form. And subsection 4 of section 92 of the Act provided every company shall file with the registrar of company a copy of the annual return within 60 days from the date of the AGM is held, or where no AGM is held in any year within 60 days from the date on which AGM should have been held, together with the statement specifying reason for not holding the AGM, with such fee or additional fee as applicable. For the subsection 5 of section 92 of the Act provide that if any company fails to file its annual return under subsection 4 of section 92 before the expiry of the specified period therein, such company and its every officer who is default shall be liable to penalty of the 50,000 rupees, and in case of the continuing failure, with further penalty of 100 rupees for each day during which such failure continues, subject to maximum of 5 lakh rupees. Further, subsection 1 of section 129 of the Act provided every company shall prepare a financial statement, comply with the accounting standard notified under section 133 of the Act, and subsection 2 of section 129 of the Act provide that at every AGM of a company, the board of directors of the company shall lay before such meeting financial statement for the financial year. Further, subsection 1 of section 137 of the Act provide that a copy of the financial statement, including consolidated financial statement if any, along with all documents which are required to be or attached to such financial statement under this Act duly adopted at the AGM of the company shall be fixed with the and shall be filed with the registrar of company within 30 days from the date of the AGM in such manner with such fee or additional fee as applicable. Further, subsection 3 of section 137 provide that if a company fails to file the copy of the financial statement under subsection 1 or subsection 2 of the section 137 as the case may be before the expiry of the period specified therein, the company shall be liable to a penalty of 1000 rupees for every day. Remember, 1000 rupees for every day during which such failure continue, but which shall not be more than 10 lakh rupees, and the managing director, chief financial officer of the company, if any, and in the absence of the managing director, chief financial officer, and other director who is charged by the board with the responsibility of complying with the provision of this section, and in the absence of any such director, all the director of the company shall be liable to penalty of 1 lakh rupees, and in case of continuing failure with further penalty of 100 rupees for each day after the first during which such failure continues, subject to maximum of 5 lakh rupees. In order, on a fixed date, one of the director appeared before the executing officer and stated that after expiry of the her husband, she is not able to getting cooperation from other director, and she has also not aware of any documentary and regulatory non-compliance as was done by her husband, which is a managing director of the company. She also expressed her inability to submit anything for compliance matter. The company and its director have not filed annual return and financial statement pursuant to subsection 4 of section 92 and subsection 1 of section 137 of the Act respectively for the financial year ending 31st March 2019 and 31st March 2020, thereby attracting penal provision under subsection 5 of section 92 and subsection 3 of section 137 of the Act respectively. The offence is of serious nature, since non-filing of the annual account by the company put itself out of the reach of the stakeholder and regulatory authority and other concerned. The object of filing of the annual return of the company with the public domain is in the public interest to enable the investor, public, and whatsoever interested in the company can access the fundamental information about the company and its management. Non-filing of this statutory return will result in denial of information to public about the company. The object of the filing of the financial statement of a company with the MCA portal is to enable the public interest statutory agency to access the and know about the company state of affairs. The financial statement of a company so filed shall give a true and fair view of the state of affairs of the company. Said statement will become document of public domain, and the interested public can access the said statement to MCA website to know the financial state of affairs of the company as on that date. Having considered the facts and circumstances of the case, and after taking into account the factors above, the AO do hereby impose penalty on company and its director, excluding the name of the managing director who died on 9th February 2018 as per table given below for the violation of section 92 and 137 of the company is for financial year ending 31st March 2018. The executing officer is opinion that penalty is commensurate with the aforesaid default committed by the noticee. For the financial year 2018-19, the default for the 850 days, that is failure to file financial statement under section 137 on company, 1000 per day penalty, that is 1000 into 850 days, that is 8,50,000 on the company, and 100 per day on the director, that is 1,85,000 on each director. Further, for the failure to file annual return for the delay of 820 days on the company, that is the 50,000 max penalty or 100 per day. So here 50,000 plus 100 per day, that is 82,000, 1,32,000 on each director of the company official in default. And for the violation of section 1, violation of for the financial year 2019-20 on the company for the failure to file the of the financial statement, that is 484, that is 1000 per day, that is 4,84,000 on the company, and 1 lakh on the defaulting director, and 100 per days, that is 1,48,400 on each director. And for the failure to file the annual return on the company, that is 50,000 plus 100 per day, that is the 95,400 on each director. The company and its director are hereby directed to rectify the default immediately from the date of receipt of the copy of its order. The penalty imposed shall be paid to the MCA portal only. Appeal, if any, against this order may be filed in writing with the original director within a period of the 60 days from the date of receipt of this order. Inform ADGA setting for the grounds of appeal and shall be accompanied by a certified copy of this order. Thank you so much for watching this update.